let's continue.
Thank you, Chair. Mr. Mukesi, before the long adjournment, we were speaking of the notion of an unsolicited bid. And you offered a statement to the Chair that an incorrect approach or application of the law had been occasioned by Mr. Matlakala, the supply chain management official in your department. Would you explain that, please?
Okay. I will say in this instance, for example, the wrong prescript of the regulation, right? Because on one hand you have an unsolicited bid, which I think was also what the PP found, and instead of using the unsolicited bid approach, the 1666A was applied, and that's in short what I'm trying to.
And you say that the 16A 6.6 approach was incorrectly used?
Incorrectly used or applied.
Or maybe, better still, are you saying that it was not applicable? In this case, another provision should have been applied?
Yeah, I think.
In other words,
let's for a change assume that everything was fine in terms of, it has been
open tender.
Yeah, let's assume that everything was okay in terms of the 16, in terms of the Gauteng
yes.
contract and so on and
yes.
so on and so
yeah.
on. Now, even if, I think that's also what I say, even if the 16.6A was applied and it was correct and everything was okay, it would have still been the problem because it would have applied an incorrect regulation, so to speak. I think that was the finding.
Are you basing what you say on what the public protector said? I heard you referring to PP.
Yes.
Yes. So in other words, the public protector has made a certain pronouncement, and you agree with that pronouncement. Is that right?
In terms of the wrong, the application.
Wrong application.
Yeah, the choosing of the wrong
provision
of the law and apply it in these instances. So there's a disjuncture in that respect.
Yes. And you would say the correct one would have been which one?
Well, on hindsight, I will say the correct one will probably have been the unsolicited.
Unsolicited.
The unsolicited.
Yeah, okay. Yes, Mr. Pretorius.
Well, let's go back then to the department's supply chain management policy, which in fact, and I don't think there's much controversy on this point, mirrors the PFMA and Treasury regulations insofar as they deal with unsolicited bid. Let me put that to you. The provisions of your supply chain management policy would always have mirrored the legislation and the Treasury regulations. Would that not be the case?
Yeah, the provisions of?
The provisions of your supply chain management policy in the Department of Human Settlements would always have mirrored the provisions of the Public Finance Management Act and the Treasury regulations dealing with unsolicited bids.
Okay, yes.
That's correct, yes. All right, so let's just deal quickly then, because It does not appear to be too controversial from what you've said. If you would go to FS7, page 139, please.
Yes.
That's where we were before lunch.
That's where we were.
Yeah, that is where we were before lunch.
If you go to 1213A, that is the provision we were discussing before lunch, which says that you can only consider an unsolicited proposal if that proposal meets certain requirements, and those requirements are set out in Roman 1 to Roman 4 of paragraph 12.13a on page 139. Do you see those requirements?
Yes, I see.
Now, as I understand the proposal, and if you want to take me there or take the chair there, we can go there, but they did not comply. That proposal did not comply with those requirements, or certainly did not comply with all of them. We can go into the detail if you want.
Maybe with not all of them, but with some of them.
You say some, but not all.
Yeah.
Which ones did it not comply with?
Well, if you say around the issue of a business case, there was certainly a need. The product or service involves an innovative design. There's no element of that innovative.
There was no innovative design in the bid.
Yes,
Yes.
but it was necessary.
Similarly, I would understand that there was no innovative approach apparent from the bid, at least.
Sorry?
There was no innovative approach as required by Roman 3 in the bid. Would you agree with that?
Yes.
Yes. And then Roman 4, I do not understand the bid to have shown a new and cost-effective method of service delivery.
Well,
It has never been done before. Sorry?
I'm sorry, Mr. Pretorius, isn't 3, 4, and 5, aren't they optional? I say that or after Roman figure 2 and or after Roman figure 3. In other words, is the position not that the first two, Roman figure 1 and Roman figure 2, are compulsory, but if you don't meet Roman figure 2, at least you must meet Roman figure 3 or Roman figure 4, but you don't have to meet all 4 of them.
Yes, that's why I need to put them all.
Yes, no, I understood you to be, your question to be based on an understanding that they all have to be complied with. So I wanted to clarify that.
Yes. Well,
is your understanding the same as mine?
Yes, Chair.
But I accept that they need to be put to him, maybe one by one, to make sure that there's understanding.
Maybe a different approach that I was adopting, but I think it has the same effect.
Yes, no, that's fine.
Because if there's no innovative design and no innovative approach, and it's not new and cost-effective, then none of the alternatives would apply. And I understand we're almost there, Mr. Mkesi, that it wasn't innovative in design or approach, and it wasn't new and cost-effective. Can we agree on that?
Well, I don't know about the cost effectiveness of your...
I'm sorry, I can't hear you.
I'm saying I'm not so sure about the cost effectiveness. I would agree with in certain instances 2 and 3 perhaps, but certainly 1 there was a need for that.
Well, let's put it to you. Was there an innovative design apparent from the proposal?
The project was about assessment and ultimately phase 1 and assessment and audit, and secondly phase 1, the removal. So that was what it was about in the main.
Yes, but was there anything innovative about it? Anything new about identifying houses and assessing their condition? That was apparent from the bid.
I understood you earlier, and maybe I misunderstood you, and you must tell me if I misunderstood you. I understood you earlier to accept that Roman figure 2 was not complied with. Am I right?
Yes, I said so.
Yes, okay, all right. I think that's the answer, Mr. Pretorius.
Yes, does the same apply to Roman 3, an innovative approach? That wasn't complied with. I understood you to say that, but I may be wrong. Correct?
Correct.
And Roman 4, the service presented a new, I stress new, and cost-effective method. Let's leave aside cost-effective for the moment. That's for later discussion. But was it a new method that was being proposed?
Certainly, maybe to us as a province it was new, because we use largely, or in the main, we followed the Gauteng route.
Well,
Because we did not know anything else.
Let's go then to the proposal.
But before we do that, Mr. Pretorius, I just want to make sure. Roman figure 1, what did you say about it?
Well, I indicated that there was a need.
There was or there was no feasibility study? Roman figure 1 says there must be a comprehensive and relevant project feasibility study that has established a clear business case. Was there a comprehensive project feasibility study that established a clear business case?
As I've indicated earlier, we relied mostly on somebody else had done it already.
Yes.
And in these instances, and that is why I'm specifically referring to Gauteng, to say they have done it, and we knew that being the member of the same human settlement family, we knew that they have done it. And indeed, it was also part of the discussions that the MIN make, this issue of the removal of eradication of asbestos. So we were merely following up in terms of what Gauteng had done.
I take it that when the policy refers to a comprehensive and relevant project feasibility study, it contemplates a document which contains that study. Would that be the same understanding that you have as well about that requirement?
I didn't. Can you pass?
Let me repeat. When Roman figure 1 says there must be a comprehensive and relevant project feasibility study that has established a clear business case, I assume that what it contemplates is that there would be a document which constitutes that feasibility study. Would your understanding be the same, or would your understanding be that there need not be a document?
The studies around asbestos are there.
Are there?
They are there, and in terms also the dangers and so on. I don't think that is an issue at this stage.
Yes.
Around the effects and the dangers of asbestos, and that they needed to be eradicated. And that's not. They are there. They are widely available.
So you would say that there was such a comprehensive
Yes, there is.
study. It may not have been provided by the entity that put in a proposal, but the
But the
study was
studies
there.
are there.
Yes,
The
okay.
information is widely available.
Okay, all
And
right.
as I've indicated as well,
Yes.
these discussions were continuing on at MINMEC level
Yes.
as well. So that information is widely available.
Okay, I just wanted to make sure that before we proceed further down the page, we know what the answer is in regard to Roman figure 1.
All right, well, perhaps understand one thing you said. You said you relied on what had been done in Gauteng.
What I'm saying is the removal and the assessment, the work in Gauteng had already been done. So Gauteng, I will say, was they had already established a principle in terms of the work that they have done already around.
There was a precedent.
There was a
in-
precedent already.
Yes.
Yeah,
Well, then
in
what
fact,
was
that
new about the method of service delivery in Free State?
Sorry?
What was new then in the Free State?
Every township in the Free State has got asbestos.
I'm sorry, every township in the Free State has what?
Every township in the Free State has got asbestos
Roofs.
asbestos roofs.
Okay,
Okay, and coupled with the fact that in one of the State of the Province address, an issue was also discussed around the eradication of the two-roomed houses, which in essence also, those two-room houses also have asbestos roofing in the main. Now, as we speak, the province is incrementally also, because incrementally also removing, eradicating those two-room houses because of the historical fact, in terms of those two-room houses, they were only meant for a specific population. And coupled with that, because all those two-room houses have got asbestos roofs as well. So we sort of tapped on what Gauteng has done to have a holistic approach in terms of one, getting rid of the two-room houses, and in the process also look at removing the asbestos both on the two rooms and on the four rooms and in all old dilapidated houses.
The question remains, Mr. Mkesi, what was new about the service proposed in this document, the unsolicited bid? What was new about it, about the service? You yourself said you had Gauteng as a precedent.
Well, Mr. Pretorius, I suppose what you are trying to push me on is on the issue of the unsolicited bid and whether there was anything new or not. And I think I've responded to that question.
Well, I wanted to ask that. I wanted to say, well, maybe first the question should be whether you say there was anything new, because I had understood you before, and I may have been wrong, that you were not saying that there was anything new, but I may have misunderstood you.
I don't understand, perhaps maybe the question of what was new.
Yeah.
Safe to say, this is within our mandate.
Yeah.
as a department.
Yeah.
It's part of the housing code. So it's part of our ongoing work in any event.
Well, I understand that it might be part of your mandate. I think that's well established on the papers and in the evidence. But let me ask you then, if you go to 12.13,
12 point?
13 on FS 7139, that's where we are.
Okay.
You have that?
Yeah.
You see Roman 4 as being a requirement not of any other document, but of the proposal. You see that? The proposal may only be considered if it meets the following requirements. And then we go to 4. Now, this is your document in your department, Mr. Mkhezi. The product or service presents a new and cost-effective method of service delivery. Perhaps you could explain to the chair what new means in that context. It being your document.
Well, I suppose the new will refer to the method, and certainly the removal of asbestos is within our mandate.
Yes, we're not doubting it was within your mandate
It's
for the
within our
present.
mandate.
Mr. Mkhezi, we want to understand, or at least we would like to understand this side of the room, what you mean by it must be new, a new method of service delivery.
Just your understanding, your own understanding of what this means. In other words, Mr. Pretorius is asking for your own understanding of what this part of your policy means.
Well, it might mean that it has never been done before. That's also new. Or it is done differently than the conventional way that it was done before. Yes, it might mean that. It might mean that it's a completely new thing. It has never been done before. But obviously, as you apply that, it must be within your own mandate. It's not something that is outside your mandate. Or it might be a different method
Of doing things.
Let's accept for the moment that it was within mandate. That's not a matter of dispute. The description you have given of a new method of service delivery, I would understand, is in accordance with the ordinary meaning of those words. There is, and you can correct me if I'm wrong, there is in this proposal at Free State 8164 nothing new or nothing different about what was done in Gauteng or what had been done before anyway. Would you like to look at Free State 8164?
Nothing, you said nothing new.
There's nothing new, nothing unprecedented, nothing that had not been done before. It wasn't new. As described by yourself.
Maybe if I can assist, you have said that Roman figure 4 at 12.13 means that the proposal comes up with a new method of doing things. Now, Mr. Pretorius is putting to you for your comment that in this proposal that was submitted, there was no new method of doing things that was apparent from the proposal. What do you say to that?
Okay. Yes.
You
Yes.
accept?
Yeah.
Okay.
So we don't need to go to the document then, for the moment at least. But let's go further. Let's deal with the National Treasury Circular. And to assist you here, we also have that document. It's at page 193 of the bundle that is in front of you. So I may be misleading you. FS 7196. This is a Treasury circular.
193.
No, 196, I'm sorry. This is a Treasury circular. It's dated 28 October 2004. That's apparent from the stamp at the bottom of page 196. And its heading is Implementation of Supply Chain Management. At page 197, deals with unsolicited bids, and I stress unsolicited bid. And what we're dealing here with an unsolicited bid, the Treasury circular places some duties on an accounting officer in paragraph 2.2 on page 197. Do you have that? And it reads, if an accounting officer authority decides to consider an unsolicited bid, he or she may do so only if the product or service offered in terms of the bid is a unique, innovative concept that will be exceptionally beneficial to or have exceptional cost advantages for the institution. Let's leave aside exceptional benefit and exceptional cost advantages. We can deal with that later. But I understand that the product or service offered in terms of that unsolicited bid or proposal is considered by you to be not unique and innovative. Firstly, others had done it, and secondly, it was not new. Would you accept that?
Yes.
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 Sorry, you can't nod.
Yes.
Mr. McKessie. I mean, you can nod, but you should also say yes.
Yeah, when you nod,
please.
the microphone doesn't capture the nod.
Yeah.
But your answer to that question was yes, I understood.
Yes.
And then B, the person who made the bid is the sole provider of the product or service. Now, given the experience of Gauteng, we know that not to be the case. Would you accept that?
Yes.
And C would apply because we understand that there had been some strategic planning around removal of asbestos. You know that.
Yes.
All right. But let's then go to the National Treasury Practice Note 11 of 2008-9. That appears at Free State 7, 202.
What page are you, Mr. Pretorius?
Free State 7, 2000 and...
That's the same
sorry,
file.
Free State 7, 202.
202.
Yes. This is a document which appears on page 212 to have been issued on the 16th of March 2009 and issued in terms of Section 76 of the PFMA, Public Finance Management Act. You see that on page 212.
212.
Yes. And this is a practice note dealing expressly with unsolicited proposals.
212.
We go back to 202, but the proposition I just put to you is at page 212, that this practice note was issued under the authority of Section 76 of the PFMA and was issued on 16 March 2009. You have that?
Yeah, I have that.
This document deals expressly and particularly with unsolicited proposals, and it appears as such on page 202. You have that. Under the heading Purpose, paragraph 1.1 reads, "This practice note provides precise guidelines for institutions dealing with unsolicited proposals stroke concepts. An unsolicited proposal stroke concept means any proposal stroke concept received by an institution outside its normal procurement process that is not an unsolicited bid. That is a submission that must be innovative, unique, and provided by a sole supplier." What we know is that the proposal that you received was not an unsolicited, it was received by you outside of the normal procurement process. It was unsolicited, correct?
Yes.
Yes. So if we go on then to 2, on page 203, there are set out the criteria for consideration of an unsolicited proposal. Again, the provisions of your supply chain management policy are mirrored here. 2.1, institutions are not obliged to consider an unsolicited proposal, but may consider such a proposal only if it meets the following requirements, and then the requirements we've just dealt with are set out. You see that? Those are the same requirements as contained in your policy, your departmental supply chain management policy.
Yes.
And then, if one goes over the page to paragraph 2.3, the requirement is that the unsolicited proposal must set out the following information in terms of the product or service offered. Firstly, a concise title and abstract, approximately 200 words, of the proposed product or service. We can debate whether that's applicable or not, but it's perhaps not necessary to do so. 2.3 on page 204.
I think Mr. Mufetsi, Mr. Pretorius is leaving both of us behind. I was still on 203 as well.
So we're on 204. Well, I am at least, Chair.
I'm there now.
Page 204. Are you there? Paragraph 2.3. The unsolicited proposal must set out the following information in terms of the product or service offered. Let's go immediately to subparagraph C a statement describing how the proposal is demonstratively innovative and supported by evidence that the proponent is the sole provider of the innovation. Can we accept that that wasn't contained in the proposal that we referred to? Yes. D, a statement of the anticipated benefits or cost advantages to the institution, including the proposed price or total estimated cost for providing the product or service in sufficient detail to allow a meaningful evaluation by the institution. As I read it, at least, it should have the price of the product or the total estimated cost for providing the service in sufficient detail to allow a meaningful evaluation by the institution. Would you accept that the proposal didn't contain that information or that statement?
Contain what? The cost?
No, it didn't contain the total estimated cost for providing the service. Well, let's go there. If you like, you can show me where it's contained, if you like. I'm just putting to you that it doesn't contain that information.
The proposal did not have a cost.
I'm sorry?
You say the proposal did not have a...
Didn't have the total estimated cost for providing the service in sufficient detail to allow a meaningful evaluation by the institution.
It certainly did have a unit cost.
Well, let's have a look. We may. We can go to Free State 8, FS 8, page 164. And to assist you, we can go straight to page 166 under the heading Rate per House. There is a cost per house,
Yes.
but there is not a total cost of the service. In other words, you didn't know how much at the end of the day the department would have to pay for the whole service.
At the beginning, yes.
At the beginning, yes. That came later, but not at this stage. Are we agreed on that?
Yes.
Yes. Okay. Then paragraph 3 on page 204 says, under the head...
on a different, not on that one.
No, that's still the same. No, not that document, okay. The one before you, FS 7, 204. Unacceptable unsolicited proposals is the heading in paragraph 3. It says the accounting officer must reject the unsolicited proposal if certain conditions apply. Right? And let's just go to 3.1A. Okay. If that proposal relates to known institutional requirements, now we know that your department had a requirement. It was within your mandate to remove asbestos. Are we agreed thus far?
Yes.
Yes. The answer is yes.
If the stenographer complains anymore, I'm going to get into big trouble, Mr. McKessie.
A little bit far. Yes.
So it related to known institutional requirements, and would you say that it could, within reasonable and practicable limits, be acquired by conventional competitive bidding methods? You could have gone out to tender reasonably and practically.
Yeah, and this is what I was trying to say to you, Mr. Pretorius. other processes, whether it's unsolicited bid, Regulation 1668 and so on, those are recognized bidding.
Please look this side.
Sorry.
Yeah.
Those are recognized bidding instruments that also have an underlying constitutional imperative. So let's not create an impression that the conventional tendering system is the only one, because things can go wrong even in that particular, in that conventional tendering process. Things can go wrong as well. So that's basically what I'm trying to say. Let's not create the impression that it is the only.
I think Mr. Pretoria's question was based on 3.1A at page 204, because that provision requires, at least it seems to me, the accounting officer to reject an unsolicited proposal if certain conditions exist. The first one, that is A, is if the proposal relates to known institutional requirements that can, within reasonable and practicable limits, be acquired by conventional competitive bidding methods. As I understand what paragraph A means, it seems to say, don't accept as an accounting officer an unsolicited proposal if it would be reasonable and practicable to obtain the same thing through the conventional competitive bidding methods. That's my understanding of what it says. Is it the same as your understanding?
Yes.
Of paragraph A?
Sorry?
Is my understanding of paragraph A the same as yours? Namely, an accounting officer must reject an unsolicited proposal if the proposal relates to known institutional requirements that can, within reasonable and practicable limits, be acquired by conventional competitive bidding methods. In other words, as I understand it, the paragraph seems to say, you must remember, accounting officer, that the preferred method is the conventional competitive bidding methods. Those are the preferred. But it's acknowledged that there may be circumstances where you don't have to use those. But it therefore says, if what is proposed is known institutional requirements that you can, as a department, within reasonable and practicable limits, obtain by using conventional bidding methods, use conventional bidding methods. Don't go for the unsolicited bids proposal. That's my understanding of what paragraph A says. My question is my understanding the same as yours?
Okay, I hear what you're saying, Chairperson. All that, you see, the fact of the matter is we did not use
the competitive conventional.
We did not use the
conventional,
or even for that matter, at the time, apply to come to a decision that says this, with the advice of the practitioner at the time. This we think will qualify as unsolicited bid. because what was in the mind at that particular point was the most appropriate method will be the 16.6A. And that's where we are, because right now, Mr. Pretorius is questioning me on the issues of the unsolicited. While I consider that this looks like an unsolicited bid, I accept that on hindsight, to say this is what should have happened. But the fact of the matter is, it didn't happen that way. Right?
Yes.
We apply, as I've indicated earlier on, that we apply a
wrong
yes,
section, law provision.
the wrong section.
Yeah. Yes, but what Mr. Pretorius is trying to do is to try and make sure that we all understand where there is common ground, including your own understanding of the situation, so that we can see where there may be differences. So that's why he was saying this requirements here contemplates that the accounting officer should reject an unsolicited proposal if it relates to known institutional requirements that can, within reasonable and practical limits, be acquired by conventional competitive bidding methods. My understanding of what you are saying, and I'm trying to make sure we make progress, my understanding of what you are saying is you accept that this requirement, you accept that this proposal related to known institutional requirements, and it is not your case that the department could not, within reasonable and practicable limits, acquire these services by conventional competitive bidding. My understanding is that you are not contesting that.
I'm not contesting this particular issue because
Yes.
they were never applied in the first place.
Yes, okay. No, thank you.
All right.
So
Similarly,
I think it will save the Commission's time as well, not to dwell on things that we never apply them in the first place.
Yes. No, that's helpful because it makes us to understand what issues you don't contest, you accept, and then we can get to the ones which may be contested as early as quickly as possible.
well, let's just try and summarize the position as I understand your answer, Mr. McKenzie. The provisions in relation to unsolicited bids or unsolicited proposals could not be applied in this case. They were simply not applicable. That's as I understood your answer.
Let me see if I can,
Okay, please
I can assist. My understanding of your position is that you accept that even the provisions relating to unsolicited proposals were not complied with in this case.
Yes, because
You
we
accept
never,
that.
we never applied.
You never applied them, therefore.
We instead used a different method.
Yes.
Which turned out not to be the correct method.
Yes, but you have already said you accept that in hindsight, you say what should have been done is to see whether these provisions could be applied.
Yes, it will serve no purpose to discuss what we didn't do.
Yes.
When I've admitted that this is possibly on hindsight.
Yes. So maybe to take that one step further, because I think that's where Mr. Pretorius was going. Looking at these provisions, at these requirements for applicable to unsolicited proposals, you would accept that still it would have been difficult to apply them or to say the requirements were met because, for example, there was nothing innovative about this method. You accept that? Yes?
Yes, I'm saying correct.
Yes, okay.
So,
I think that should,
yes, just to summarize then, Mr. Mkhize, not only did you not apply these provisions, you applied different provisions, but you could not apply these provisions because the bid didn't comply with the provisions that are set out in the prescript. Is that a fair summary?
That, Mr.
We know what you did and didn't do. That's the subject matter of evidence. It's in your statement. You did not seek to apply the provisions relating to unsolicited bids or unsolicited proposals. That much, I think you've said now. Correct?
Yeah, and I think...
Please take the mask off.
Sorry. I think even in my statement, because the issue of unsolicited bidding is a finding to say this is what we should have done, and it's not. Nowhere do I make a reference on the issue of unsolicited bidding. The emphasis has always been on the issue of the application of the 16 points.
Yes, so we'll get there, I promise. But for the moment, not only did you not apply, but the proposition that is apparent from the work we've just done is that you could not do so in any event. You didn't do so and you could not do so, simply because the unsolicited bid did not comply with the requirements of the statute and the regulations and the practice note. Is that a fair summary?
Yes, if at the time we
try to apply them.
It will not pass on.
Yes. Yeah.
Okay.
Yeah.
Then we're on the same page. Just for the sake of completeness, although we know you didn't do it and you didn't consider doing it for other reasons, it's important to place on record that even where an unsolicited bid results in an agreement, there is still a procurement process that must be gone through. In other words, the agreement must be advertised and other people must be given a chance to enter the competition, as it were.
Yeah, the unsolicited bid has also its process.
Yes, it has its own process. And if I may just refer you to paragraph 5 on page 208, that even if an unsolicited proposal or unsolicited bid is accepted, it must still be subject to a competitive process.
So is all other.
Yes. But the answer is yes.
All other processes, yes. Whether it's 16.6A, underlying to that is a competitive bidding
But
process.
the way it works in this case, as I understand it, and I'm trying to summarize so we can move on, is that once an agreement is reached with a person who's submitted an unsolicited bid, or unsolicited proposal, let me stress that, you must still go out to the public and allow other people to make competing bids. Correct.
Right.
Okay. All right, then let's move on.
The answer was yes.
Yes.
Yeah, okay.
And those provisions are contained in this circular at page 208 and following. Free State 7, 208 and following, under procurement paragraph 5. And what is also interesting about the procedures that follow the acceptance of an unsolicited bid is the provisions in paragraph 6 on page 209, that external consultants may be approached for advice in relation to the bid that has been accepted. Do you see that in paragraph 6?
209.
6, page 209. You see that? Just very briefly, it makes provision for an accounting officer or institution to seek advice from independent consultants or experts where there may be a need to do that.
Yes. Yes,
Correct.
that's it.
Right. If we may then go to the topic that you've mentioned a number of times, and that is the Regulation 16, capital A, 6.6. That is the provision that you have mentioned earlier.
Where do we find it?
It's in FS7.
Same file that we have.
Yes, same file. Just to identify the document, it's page 4 of FS7. This is a document entitled Treasury Regulations for Departments, Trading Entities, Constitutional Institutions and Public Entities, issued in terms of the Public Finance Management Act of 1999, and the regulations are dated March 2005. That's apparent from page 4. You see that?
Yes.
Okay, now if we go to 8.1.1, and I'm talking about paragraph 8.1.1.
Of the same document.
I'll get there in a moment. It's on page 33. Eight 8.1 deals with responsibility of the accounting officer in relation to payments made from funds of a department, for example, in your case. Do you see that in 811?
Yes, I see.
And 821 says that an official of an institution may not spend or commit public money except with the approval, either in writing or by duly authorized electronic means, of the accounting officer or a properly delegated or authorized officer. You see that? Let's then go through to 16A, which appears you would bear with me a moment, Mr. McKessie. Under the head Supply Chain Management on page 60. These now are the regulations that have been issued under the auspices of the Public Finance Management Act, and they're part of that hierarchy of control provisions that we spoke about earlier. But if I may refer you to 16A3.1, just to confirm the position in terms of the regulations, it reads, the accounting officer or accounting authority of an institution to which these regulations apply must develop and implement an effective and efficient supply chain management system in his or her institution for the acquisition of goods and services. That's consistent with provisions in other instruments that we've referred to.
Yes.
And then 16A3.2, a supply chain management system referred to in paragraph 16A3.1 must be fair, equitable, transparent, competitive, and cost-effective. And then there are various other provisions that apply, again mirroring both your prescripts in your department and your supply chain management policy at the bottom of the pile and the Constitution at the top of the pile, correct?
Yes.
Then 16A 6.6, if you would go there, please.
The following page.
It's on page 62.
62.
This is the provision that was sought to be applied in the present matter, although you've made certain concessions that it could not be. Do I understand you correctly?
Yes.
All right. It reads, the accounting officer or accounting authority may, on behalf of the department, constitutional institution or public entity, participate in any contract arranged by means of a competitive bidding process by any other organ of state, subject to the written approval of such organ of state and the relevant contractors.
Yes.
I'm sorry, Mr. Pretorius, precisely where under 16A for A6 are you reading?
16A 6.6 on page 62.
16A 6.2. 0.6.
Yes, on page 62.
Oh, okay. All right, I've found it.
There are several requirements contained in that provision, but perhaps we could short-circuit the whole debate or the whole series of questions if you just said to the chair in what respect it was incorrect to apply this provision in the case of the asbestos contract.
I think I'll in the main, I'll mention three things. Yes, because which is what I asked the supply chain. Because more often than not, as an accounting officer, you get to know about problems when they occur or when they're picked up by audit.
Okay, just raise your voice again.
I'm saying you pick up more often than not, you as an accounting officer, you pick up when they have occurred, when the problems have occurred.
Yes.
And through through either internal audit or external auditors. That's when you realize that there are problems. Now, the questions that I asked were only three things to the supply chain. One, why 16A6, in other words, if you are participating elsewhere, if you are participating in a contract of another institution, if it is not a joint venture there, it can't be a joint venture here. That's the first, those are the Secondly...
I'm sorry to interrupt you, Mr. McKenzie, but I didn't hear that. If you could repeat that, please.
Okay, I'm saying there are three issues that I requested when picking up that there is a problem in terms of the regularity. To say, one, the joint venture. The 16A6A requires that it must be the same company. If you participate, you must participate in a contract with the same company. Two, did you request documents? Right, because that's the first process of, that's where the due diligence starts. Because you don't want to, if it is irregular on the other side, you can't regularize it yourself. And the only way that you can be in the position to to know is to get all the documents, from the advert, how they were appointed, who were the participants, et cetera, all that information. Then you will be in a position to identify possible risk of an irregular expenditure. Now, the third issue is around the issue of the unit price, right? It's 650 there. You can up to a point, if you participate, increase the price, because indeed the Free State province is a vast province, but they know that you have to make a motivation to Treasury. Treasury will have to allow you to be able to increase that. If for any reason you have to deviate from the existing price. So those three issues, because they were not complied, that's what made us to be where we are in the May. Obviously, there are other processes when a regular expert, there's a framework that defines what you have to do and so on and so on.
All right, well, perhaps you could assist us with the provisions that you referred to in due course, but if I may just see if I understand you correctly. Sorry,
1 second.
Chair.
Had you finished?
Yeah.
Oh, okay, all right.
The first issue you raised was that in order to apply this provision, 16A 6.6 of the Treasury regulations, in order to participate in a contract that has been entered into and executed elsewhere, you must actually participate in that very contract. Is that correct? And that did not occur in this case.
Not only that, but it must be like for like.
Yes. Okay. So it must be the same party, same terms and conditions, same price.
Yes.
Correct.
Now,
and that didn't occur in this case.
It could not, they could not pick it up because they did not request the documents. I mean, this is what I'm saying.
Yes.
They could not, in other words, that's where the due diligence starts. You first, because, they gave three answers. If I can, the answers around. Maybe let's start with this issue of the JV to say why. In their opinion, they did not see that as an issue, because I think in one of the affidavits, a mention is made that one that was appointed there was a lead consultant, and therefore did not find it necessary for.
But that's
did not think that it was an issue, but it is an issue.
Yes, yeah. They may be having that view, but your view is different.
It's an issue.
Yeah.
Yes,
yeah.
It is an issue.
Okay.
Yes.
Secondly, on the issue of the due diligence, to say, let's get. Why did you not get documents from Gauteng? Full documents.
Which would have given them a full picture.
It will give you the full picture of whether this is where we should participate or not. Now, one of the things that has been, I think, even before the 19 Gale issue, because that's the one that actually clarifies what must happen for the application of the 16.6A. Also take into consideration that this particular issue happened. We had different interpretation, but the fact of the matter is, if you have to avoid the risk of irregular expenditure. You still have to do more and see, so that you don't transfer your problem to you, basically. And the response is, but there is nowhere either in the Act itself, in the main Act itself, in the regulations that say you must seek documents. That was some of it. But
The law can't write down
as a
everything.
matter of course, you need to do that so that to avoid this particular. Indeed, it doesn't say that. Simply, their interpretation was that as long as the accounting officer of the other institution assures you that due process has been followed and so on and so on, that's all that you need to do. But, well, with the advent of the Nightingale, it emphasizes that you must get documents.
In other words, part of what you are saying is you might be hearing whatever view they have. You are saying they had to satisfy themselves that what happened in Gauteng was regular. And the way to do that was to ask for documents. They did not do that.
Yes, because at the time, at the time when this, it was only declared irregular subsequent at a later stage. But you could have probably have been in the position to identify a risk that because of X, Y, Z, there's a possibility that this particular contract might be declared irregular. Now, you can't regularize it if it has been declared irregular at the source.
Yes, Mr. Peters.
If we could just summarize so that I make sure I understand your answer, Mr. McKenzie. In order for the Free State Department to participate in a contract that had been entered into between the Gauteng Department of Human Settlements and a service provider, certain requirements had to be in place. You described it appropriately, I think, when you used the words like for like. Must be the same service provider, must be the same terms and conditions in relation to performance and price, and that should be evidenced by an examination of the documentary record.
Yes,
and
because
not,
if you do that, at least you will be in the position to reduce the risk.
Yes. So, as I understand, what didn't happen in the Free State Department was that the evidence to show that the regulation could indeed apply like for like was not called for or examined.
Yeah, remember, I think the Nightingale case also came up with a lot of other issues in the process. But indeed, even then, like for like, yes, that should be.
Yes, well, had they looked at the documentation in your department, they would have discovered that it wasn't like for like. It wasn't the same service provider. It wasn't the same terms and conditions of contract.
Yes, in other words, it was not, for example, the JV issue that I've just alluded to.
Well, we'll come to those issues in a moment when we get to the detail. The moment we're just dealing with the general principles. Yeah. Let's then look at what actually happened, and hopefully we can deal with this more quickly than we've dealt with the issues thus far. But before we go there, did you know that the Premier's office in 2010, 2011 issued a directive that all procurement documentation should be sent to the legal advisor in the office of the Premier?
No, I was not even there.
Yes, they predated your appointment.
Yeah, it predates my appointment.
Yes,
But
did
what
you know,
I've seen in the files was simply that says the contract. I don't know whether it implied procurement documents.
Well,
I thought I saw in the files which simply says the contracts be sent to the state law advisors in the
all right,
office of
well,
the
we'll
Premier.
get to those if you like.
That's what I saw.
Just before we go there then, we'll look at the documents. They're in FS7, page 305, if you want to go there.
305.
305. Now, at page 305, and perhaps this is the only one we need referred to, is a document dated the 23rd of June 2011. It's signed by the Director General in the Office of the Premier. And it says, submission of contracts agreements to the state law advisors in the Office of the Premier. And it reads, it was brought to my attention that departments submit contracts / agreements without submission of the relevant background and supporting documents, which includes procurement documents. Then goes on to say that procurement must be fair, equitable, transparent, competitive, and cost effective. And it says what should be supplied to the state law advisor in the Office of the Premier. You see that? That includes all procurement documents, correct?
Well, the letter, okay, the document that I've seen is this one, I think 307, which simply says, give all the contracts.
Yes, well, let's deal with the one at 305 first, and then we can go to 307 if you wish.
Okay.
The one at 305 is dated 23rd of June 2011. The one at 307 is dated a year earlier, 1st of July 2010. So in other words, I would assume that the document at 307 cannot override the directive in 305 to 306. You'd accept that, I presume.
It cannot?
Cannot override it, because it predates it. In other words, this was a valid instruction in 305, 306, the letter of 23rd June 2011. Not sure we should be arguing about this.
305.
Are you talking about the one at 305?
Yes,
Okay,
305 and
I've
306.
got that page, Mr.
Yeah, I have 305, but I don't understand
The question,
Pretorius'
the proposition.
Yeah, the
Okay,
proposition.
you want
What is
to
it put
try again, Mr. Pretorius?
Well, let's just deal with the document at page 305 to 306,
Okay.
correct? You've got that document.
Yes, I have it. 305.
That document says that all procurement documents, background and supporting documents to contracts and agreements entered into by a department.
Are you reading somewhere, Mr.?
Yes, I'm looking at paragraph 2. I'm paraphrasing, but perhaps I should read it for clarity. It was brought to my attention, says the Director General of the Premier's Office, that departments submit contracts / agreements without submission of the relevant background and supporting documents, which includes procurement documents. And then paragraph 3, in order to further clarify what is expected from departments when contract/agreements are submitted for scrutiny, the following must at least accompany all contracts agreements submitted to the state law advisors. 3.1, procurement documents relating to the service provider, which could include the tender documents, quotation documents, or submissions for deviation. 3.2, soft copies electronic of all contracts agreements. 3.3, inputs, comments of provincial legal advisors relating to the specific contract agreement. 3.4, any other information that could be relevant and should be taken into account. In other words, what the Office of the Premier is saying to every department, give us full information of all procurement and contracts entered into. Is that a fair summary of this directive?
In terms of this letter?
Sorry?
In terms of this letter?
Yes, in terms of this letter. Now, the question I have, it's pretty clear what this letter says. I don't think there can be much debate about it, but were you aware of this when you took office in 2012?
No.
No. Do you know whether or not your department complied with this directive in relation to the Free State Asbestos Project?
Certainly from my side, I've never submitted any procurement documents to the Office of the Premier.
And do you know for how long before you arrived in the department Mr. Matlakala had been there?
He arrived after me.
You arrived after, okay.
Yeah.
Good. Thank you. If we could go to FS 6445, that is once again to the transcript.
FS?
FS 6. So that's another file. Ms. Rankata will help you. You could go to page 445, please. 445. Then Mr. Lumprex asks you, in the first third of the page, 445, so can you then confirm that this contract, and they're talking about the contract in the asbestos matter, was never sent to Mr. Fenter's office? And you say, not to mine, not that I'm aware of, but then you clarify to say maybe it was, maybe not. So is it correct that the position is you don't have any knowledge as to whether it was submitted or not?
We have our own legal division, legal unit chairperson. So all the contracts will ordinarily be referred to, and they are responsible for compiling the contracts and so on. If they choose to use the state law advisors in the name of Mr. Fenter, it doesn't mean that we don't use Mr. Fenter from time to time because of his experience. It does happen, but I cannot certainly in this instance.
So would you have had a legal advisor in your own office, that's the Free State Department of Human Settlements?
Yes, we have a legal.
And that person would have had a duty to look through this contract and the procurement process?
Yes.
Did that happen?
The practitioner in the main, in other words, the person who holds or who advises, particularly in matters of supply chain processes, will be the director supply chain. However, in the formulation of the contracts and so on, he will then, in the process, also consult with the legal department. I assume that it did happen because it should happen that way.
Did you check whether it had happened?
I didn't check whether it is happened. It's a matter of course. It must happen that way. He knows.
Right. Well, this was an unusual circumstance. It's not every day that 16A 6.6 would apply, I understand. This was an unusual circumstance, correct?
Yes.
Was it not a circumstance that would require the accounting officer to make sure that the process and the resultant agreement were subject to legal scrutiny?
I was given an assurance that it has happened.
Who told you that it had happened?
The supply chain practitioner.
The supply chain manager?
Yes, the supply chain practitioner.
Mr. Matlakala?
Mr. Matlakala.
If you go to FS 6 again, please. Once again to the transcript of your interview. At page 460.
Oh, 460.
460 FS6.
Yeah.
There, once again, the contract in this matter was being discussed, and 2/3 the way down the page, Mr. Lamprecht asks, was the Premier aware of this contract? And your answer was, Premier will be aware of all the contracts because you know in the province, not specifically for this particular, in the same way as because I report to the MEC, they will know. Simple question is, would the Premier have known about this contract?
Well, I cannot say for certain, but I report to the MEC.
So you would have reported this to the MEC, this contract?
That's where I report to.
The MEC would have known, and I take it from your answer there that you infer that if the MEC knew, it was likely that the Premier knew. Do I interpret your answer here correctly? Where you say the Premier will be aware of all the contracts because I report to the MEC.
Yeah, I cannot say with commitment that the Premier would know.
But are you prepared to stand by your statement here on 460?
To say in respect of?
Well, you say here, Mr. Mkesi, the Premier will be aware of all the contracts, because you know in the province, not specifically for this particular, in the same way as because I report to the MEC, they will know. Now, I understand that it's not entirely clear what is said here, but I'm suggesting to you that what you're saying here, the Premier would know because I report to the MEC and the MEC knows.
The Premier will be aware of generally of the projects in the province.
Okay. Let's then deal with the process that actually occurred, and I'd like to put you some of the correspondence between parties, including yourself. you would just bear with me a moment. If you would go to FS8, please.
FS8.
Have you got FS8?
Yeah, FS8.
Okay. Mr. Pretoria is still going to say the page number.
Page 169. That is a letter addressed by yourself. That's your signature, is it?
Yes.
Dated 19 June 2014 to the CEO of Blackhead Consulting Pty Limited.
Yes.
And it says that the above has reference to your proposal submitted to this department and your appointment by the National Department of Human Settlements. Now, to be fair to you, if you look at the top right-hand corner of the letter, you'll see there inquiries J. Matlakala. Did he draft this letter?
It did.
Right. Did you pay attention to what was contained in this letter when you signed it?
Yeah, we did have a discussion, and obviously it is through, I act through his recommendation.
Right, because if you remember, the proposal submitted to you was submitted by Blackhead and by Diamond Hill. Do you remember that on the cover page?
Yes.
Right. But this letter is addressed only to the CEO of Blackhead Consulting. Do you see that?
Yes.
And it reads, the above has reference to your proposal submitted to this department and your appointment by the National Department of Human Settlements. Is there any reason why you addressed Blackhead Consulting Pty Limited and not the joint venture?
It was not, the issue of the joint venture, which subsequently came. I think I've already, Chairperson, addressed how it happened. Because if you see on all the letters that are written here, the inquiries has always been a supply chain practitioner. Okay. Now, the only reason why it was addressed to Blackhead, in my understanding then, was that it was Blackhead which was doing the work in Gauteng and had a contract. There. Now, that Diamond Hill was not part of Gauteng. It only became apparent later. And as I've indicated, some of these particular issues, particularly in the accounting office, is when when the bananas hit the fan, for lack of a better word, is when you pick up, not through the practitioners themselves or the people who are doing the work, but because of external auditors, either internal auditor or external auditors, then that those particular issues come up.
But as I understand your answer Mr. Mkhesi, it's that you addressed this letter to Blackhead Consulting Pty Limited because you knew that it was Blackhead that had entered into the Gauteng contract, and it was only Blackhead that could participate in a contract that had been sourced from Gauteng.
Yeah, but also let me just, I earlier on spoke about the issue of getting documents. Now, in this, my understanding at that particular time, because normally if you get documents, then you will know that it was not only Blackhead that was appointed, it was a couple of other people. And even in that particular, you need to have some sort of a bidding, sort of. There were so many people there were so many companies that were appointed there to do this particular, set aside the issue of irregularity first. But it was not only Blackhead that was appointed, it was others. So how this presented itself, at the beginning, it presented itself as if it is Blackhead that won the bid, basically. I mean, this is how it presented itself.
All right. Well, if you look at the content of this document at 169 of FS8, you will see references made to the Department of Human Settlements Free State wishing to extend the contract that Blackhead had with the National Department of Human Settlements in line with Treasury Regulation 16A66 of 2005. Do you see that? Now that we understand from other evidence, and you can correct this evidence if you feel it is incorrect, that was the appointment of Blackhead Consulting Pty Limited to a panel of service providers. Did you understand that to be the case then?
You want to draw his attention to the specific paragraph in the letter?
If you look at paragraph 1, it reads that the department wishes to extend your current contract, that's Blackhead's contract, secured by the National Department of Human Settlements in line with Treasury Regulations number 16A 6.6 of 2005. Mm-hmm. Now, it's apparent from other documentation, which I can show you in a moment, as well as the evidence of the head of department in the National Department of Human Settlements, that what was being talked of here was the appointment of Blackhead to a panel. It wasn't an individual instruction to perform work which had terms and conditions. Okay. Do you agree with that?
Okay. Yeah.
Do you accept
There
that?
was no contract, it was a panel.
Yes.
Okay.
But what is sought here, well, let me just ask you this question. It seems from an answer you gave to an earlier question that even in relation to the documentation which would have existed in the National Department, the Free State Department might not have requested all the documentation to understand exactly what was being requested here.
Repeat that again, Mr.
You remember you said, Mr. Mkhesi, that there was a problem about requesting documentation in this process. Okay. That the documentation wasn't requested and wasn't examined, and therefore there could be no proper understanding of what was going to be extended and whether it complied with the regulation. Correct? Okay. Now, I'm asking, does that same comment apply to the National Department? We know that you didn't ask, or no one in your department asked for documentation relating to the Gauteng contractual position or the panel position. Does the same comment apply to the national department?
Yes.
It does.
Now, at the time of sending this letter to the CEO of Blackhead, did you know that the appointment of Blackhead by the National Department of Human Settlements was an appointment to a panel as opposed to an appointment or conclusion of a contract for performing work?
Personally, at that time, it was not clear that. So your question is that did I know at the time?
Yeah, at the time you sent this letter to the CEO of Blackhead, and you wrote as you did in paragraph 1 of this letter, did you know that the appointment of Blackhead by the National Department of Human Settlements was simply an
A panel
appointment
and
to
not a
panel?
contract.
Yes, did you know that at that time?
No, I did not know that it was a panel.
At that time?
Yeah, that,
You thought it was a contract?
until later to say no, but this is a panel.
Yes.
Actually, the work did not happen in the national department. It happened in Gauteng.
Yes. And at this stage, I take it, at the stage of this letter, I take it that you would have known about the fact that there had been, Blackhead had been given a contract in Gauteng. You would have known that by this time.
No, not. I would have known.
Yes, because that is the first thing that was.
That Gauteng
Yes.
had engaged
Yes.
in the removal.
Yes.
Sorry, the assessment, because what triggered that, I think, was the storm that happened in Gauteng, and then it became necessary for them to determine what is the size of the problem.
Yes.
So
Yes.
that it was specifically
Yes. What I didn't understand when evidence was given previously with this regard to this letter was why you would have thought that you would have gone to the National Department. You would have gone to the appointment of Blackhead by the National Department for purposes of finding a contract, when in fact you ought to have known that it was in Gauteng where Blackhead had been given a contract. That's what I didn't understand.
Because I assume my colleague is going to come,
Yeah.
at some stage here.
I'm sorry, your voice
I'm
is...
saying, I'm informed that the director supply chain will also come before the commission at some future. I would, because at all material times in respect of this particular letter, as to why it went to National Department and not Gauteng. It probably was, during his engagement when he was giving or investigating what is the most appropriate method of procuring this contract. Indeed, we started in National Department, because this is where we thought only to find to discover that it's actually a panel, it's not a contract. It's not National Department that was responsible for eradication for the asbestos project per se. So it's Gauteng. And of course, the DG himself did indicate that issue to say, here is a panel.
Yes.
It's not a contract.
Yes. Okay, Mr. Pretorius.
We understood from evidence already given, Mr. Makesi, that the national contract was, or the national arrangement rather, I shouldn't say contract, was the establishment of a panel nationally for general housing matters. Do you understand the same? It wasn't an asbestos-related panel. It was general housing matters.
General housing matters.
Is that correct?
Yeah.
Now, I understood.
Was that a yes?
Yes, yes.
Yeah,
It was clarified.
You, of course, signed the letter. Did you know at the time, and I think you've answered this already, what contract you were seeking to extend? Did you make any inquiries of your supply chain director? Did you say, well, what contract are we extending here?
Yes, I did.
What did he say to you?
It's the asbestos contract.
So did Mr. Matlakala say to you, when you signed this letter addressed to the National Department, that the contract sought to be extended here was a contract for the removal of asbestos, identification and removal of asbestos? Did he actually say that to you?
Identification, removal, because it had two phases.
I'm sorry. Just repeat the answer and look this side, yeah? Well, what did Mr. Matlakala say this national department arrangement or contract was about?
The proposal was about the removal and audit and assessment and disposal. Okay, it was in two phases.
Yes.
So this is the contract that we will be participating on.
Yeah.
Or participate, yes.
Yeah.
Now, in all these particular processes that follow subsequently, the intention was exactly that, to participate because we knew that Gauteng had already done it.
You knew that Gauteng was?
Gauteng had done it already.
Yes, yes.
Yes, we knew.
Yes. But I think Mr. Pretorius asked a question, and your answer seemed to suggest that when you were signing this letter, or before you signed this letter, you asked Mr. Matlakala what contract or arrangement Blackhead had been appointed to in the national department.
Okay, the confusion was initially that this was done by national department.
Yes.
Initially.
Yeah.
And hence, and that's the reason we wrote to, which I would imagine, to the national department. And actually, it was done by Gauteng.
So are you saying that at the time of signing this letter, you were not aware that it was the Gauteng provincial government that had given an asbestos contract to Blackhead? You were not aware of that at this time. That's what you are saying.
Yeah.
And did you say you discussed it with Mr. Matlakala, and he also, his understanding was also that
It was the National
The National Department of Human Settlement is the one that had provided Blackhead with a contract for asbestos.
Whereas it was only a panel. I'm saying, whereas it was only a panel.
Yes, yes, but you say that was the understanding of both of you, yourself and Mr. Matlagala. Okay.
So I understand your evidence. When you signed this letter, you actually asked Mr. Matlakala, well, what contract is being extended here that was entered into by the National Department of Human Settlements? And you say that Mr. Matlakala told you that it was an asbestos-related contract.
Yes.
Did you ask to see any documentation in this regard? To assure yourself that this was in fact correct?
Remember, when it later turns out that it's actually not, in national department, it's only a.
Gauteng.
No, it's only a panel, right? So when it later turned out that it's only a panel, there's no contract. Actually, the work was done by Gauteng. I've already alluded earlier on that the documents that normally, when you participate in a contract of this nature, the thing that you have to do is also to request the documents. And sometimes these documents are voluminous. The mere assurance, because I'm not talking about an intern here. We are not talking about an intern. We're talking about a senior manager. If you give me an assurance that indeed you have done your work, that's sufficient for me, particularly if you, because procurement documents are voluminous. Now, I simply have to get an assurance that indeed you have followed due process.
Well,
so that assurance was given to me.
Yes, that's a further question, but the question is, and I think you've answered it, that you didn't ask for documentation, you relied on an assurance.
Yes, we all do. Also take into consideration, how many people report to me? It's 11 people who are my direct reporting, plus the district and the district as well. They report. My span of control is very wide. Now, I'm not talking about interns here. I'm talking about senior managers who in their own right can also be in future be accounting officers. So if a person who has been or people who have been in the supply chain, I mean the supply chain practitioners, almost on a monthly basis, they have their own supply chain forums. They attend, and that's also the reason why they have to be in all the committees of procurement to advise other members as well. So we are not talking about somebody who is an intern
okay, I think you.
So it depends what the level of assurance that we, how far should I really, in certain instances, demand all those particular documents. He knows. I don't have to tell him. I don't have to tell anybody particular. He knows. He has been employed for that. He's been paid for that.
Okay. I guess the short answer is that you did not ask for documents, but Mr. Matlagala gave you an assurance that put you at ease. Is that right? Yeah, okay.
Would you have expected, as his reporting official, would you have expected him to have looked at the documents?
I would have expected him to do so. Right. I would have to have documents all the documents with us.
Would you accept, as other witnesses before on this topic have testified, that you can't extend a panel? You can only extend a contract with terms and conditions.
Yeah, you participate in a contract, not in a panel. A panel ordinarily has, you are at a functionality base. You qualify them and say, right, the 10 or the 15 or the 30 of you qualify to be on the panel.
Yes.
But even then, as you go forward, they still have to compete, because what will remain now is the price in the main.
Yes, on the same day that you wrote to Blackhead Consulting Pty Limited, you appear to have written to the Director General Department of Human Settlements, Mr. Zulu, and that letter appears at page 214.9 of FS1, and I'm sorry to make you shuffle bundles yet again, Mr. Makesi, but if you would go to Free State 1.
FS1,
Page 214.9. It's not the most legible document.
what's the page?
214.9.
214.9. Are you managing there, Mr. Mukhes? Do you need assistance from somebody? I think he's fine.
Oh, okay.
214.9.
0.9.
Page?
Page 214.9. I must apologize, it's not entirely legible against the dark background, but it's more or less in the same terms as the letter we've just referred to addressed to Blackhead. It's asking for participation in a national contract. You see that?
Yes.
And I presume the same comments that you made about documentation and the like would apply. Correct, and your reliance on Mr. Matlakala's assurances.
Yes.
Correct?
Yes.
Then if we could go to another document. It's a letter from yourself to a Ms. Dedricks, dated 15 July 2014. And it appears in FS2 at page 111.
FS2.
Chair, I see it's 4 o'clock. May I ask what the intentions are?
Let us talk about what we will do. I suspect that everyone would prefer that we finish if we can, but it might not be possible.
Well, that's an understatement.
Well, you are on the podium there. What do you suggest?
Well, Chair,
You know how
I'm
you still.
quite willing to proceed if that's in order with everybody else.
Yes.
We have a witness and other parties present who should perhaps be consulted.
Yeah, no, I'll be asking.
But we must bear in mind that I won't finish today.
Yes.
And that both Mr. Makesi and Mr. Sodi have to come back.
Yes.
And we could try and arrange for them to come back on a single day.
Yes, of course, the more we do today, even if we don't finish, the better the chances are that we can find another space somewhere, and there's not a lot of space.
No, I understand that entirely, Chair. We are pressured.
Yes.
Provided we have a reasonable limit.
What is your own estimate of how much time you might still need?
3 hours, Chair.
3 hours?
Yes.
Okay. Mr. Mpofu, what is your situation?
You may be more persuasive than me.
I could address the chair from here.
You can speak from there, yeah.
Thank you. I'm sorry, Chair, I have to sit down. These are too,
No, that's fine.
too low, yes.
Yeah.
Well, Chairperson, you took the words off my mouth. My first question was whether there's a likelihood of finishing or not. Because if there isn't, then at least we don't need to invest much more time. And my second question was how much longer?
Yeah.
Mr. Pretorius has indicated another 3 hours.
Yeah.
Chair, to put it bluntly, I would prefer, therefore, that we stop as soon as possible on the understanding that we are all going to have to come back. And what I understand is that Mr. Pretorius wants to, for the next occasion, to have 2 witnesses back to back. Let's say maybe use the 3 hours for us and then another couple of hours for somebody else. So that we were quite comfortable with that. Well, of course, I'm sorry, in our case, the 3 hours might actually not be 3 hours.
Yes.
Because as soon as we get to the stage where we feel that there's a risk of self-incrimination, it might well be shorter. But so far, we're still fine.
Well, my inclination is that if Mr. Pretorius says it's about 3 hours that he estimates it might take, would be that maybe we continue, even if it's just for 1 more hour, because if what's left should take 2 hours, that should be easy even to fit into an evening session, like starting at 4 o'clock or 5 o'clock. It's easy to finish 2 hours if we can't find time during the day, So that would be my inclination.
Okay.
You have no problem.
I can live with that, Chair.
Yes. Mr. Mukhetsi, you hear what we are talking about. What's your situation? Are you happy that we continue for about another hour?
Yeah, one hour, I'm fine.
You are in line with your counsel?
Yeah, 1 hour, I think 1 hour from now, it's
Should
okay,
be fine.
but
Yes.
after that,
You might be
because I
exhausted.
have other issues
Yes.
that I have to add. But certainly, I'm available.
Yes. Okay.
I think I've indicated that earlier on, even for the evening session.
Yes. Okay. No, I think maybe then we are going to, let's take a short break now, and then we'll come back and we go for an hour, and then we adjourn.
Thanks.
We are at 4 minutes past. Shall we resume at 20 past 4?
Fine, Chair.
Yeah, okay. So we'll adjourn now and resume at 20 past 4. We adjourn. Okay. Okay, let's continue.
Thank you, Chair. Sorry. I had my back to you. If you would go to FS2, please, Mr. Makesi. At page 111.
Page 111.
Yes. Another letter addressed by yourself, on the face of it at least, to the head of department, Gauteng, dated the 15th of July 2014.
Yes, Mr. Pretorius.
You have that?
Yes, yes, sir.
If you look at paragraph 3 of that letter, it is therefore in this regard, it reads, that approval is hereby sought that you provide written confirmation to extend same in line with your approved terms and conditions as contained in your instruction to perform. There it seems that what is sought to be extended is an instruction to perform work which would have contained approved terms and conditions such as specifications, price, and the like. Do you understand it in the same way?
Oh. No, okay. My understanding here is obviously the instruction to perform work is the one that gives you the contractor to execute the work. But there will be a contract that says...
That's what you had in mind.
Yes.
Well, we have seen, you recall the phrase that we referred to this morning, terms of reference. We have seen the Gauteng terms of reference, but what we do know is that at least the terms and conditions relating to performance and the price in Gauteng were different from that entered into in the Free State. You're aware of that?
Yeah.
Yes. And so we know then that the
650 versus the 850.
I'm sorry?
That's what we are referring to.
The 650 and 80,
versus
850, yes,
Yes, okay.
per unit. There are other differences, but I don't necessarily want to go into those unless you wish to. I don't think it's relevant for the point that we make now is that I understand your evidence to be you wouldn't have looked at the documentation in the Gauteng to establish what those terms and conditions were.
Yeah, simply because of the voluminous, procurement documents are voluminous in them. And each one of us has got a role to do his or her work when it comes. I mean, the documents, I would have expected that from the supply chain in Gauteng and to have supplied by request, per request, of course, which is part of the due diligence, to say, please give us all the documents, from the advertisement and, documents, tenders, those who, even those that were disqualified, because you have to have that information. You have to have the information as if it is you who is doing, and that information by by itself will be voluminous, because then you also have to look at various reports through different committees. So you have to request all the information from A to Z.
I'm not sure that it would have been too difficult and too voluminous a task to simply establish what the price per unit was in Gauteng, would it? Simple question, what was the price per unit in Gauteng?
No, the unit in Gauteng was 650 a unit.
But what I'm saying is that it wouldn't have been too difficult to establish just that fact before entering into a contract in Free State at 850.
I think what I've indicated previously, Mr. Pretorius, I said, after the fact, I asked 3 questions. And one of them was, did you get permission from Treasury? In other words, did you make, as a supply chain practitioner, to account up to Treasury, did you make a
Look this side again, Mr.
Sorry?
Speaker.
Okay, sorry, Chair.
You asked 3 questions.
I asked 3 questions. One of the questions is, did you request and make motivation to Treasury to, you can vary the price, but it should be provided Treasury has approved and you have so given the motivation to Treasury, because those are the 3 questions that I asked, and one of them was that. So it didn't happen.
When you asked Mr. Matlakala, did you seek the approval of Treasury to adjust the price? What did he answer?
Well, he couldn't respond,
You couldn't respond.
he couldn't respond.
When did you ask him?
At the point when the remember there was a finding that the contract, in other words, the contract was irregular, and one of the issues that was raised around was precisely that particular point, that you could not provide a motivation, a proof that there was a Treasury approval.
Yes, but the question is, when did you ask him? And when did he give you this false assurance? Upon
when there were issues with the contract. In other words, when there were issues upon the finding, let me put it that way.
Of the public protector?
No.
What findings?
The finding by the AG.
All right. Well, we haven't really canvassed that, but were you aware that the Auditor General in the Gauteng province had declared the Gauteng contract, asbestos contract, invalid?
I became subsequently aware of that particular issue.
And were you? When did you?
At the time when this participation was happening, it had not been declared.
Yes, not the Gauteng contract, but ultimately the Free State contract was also declared invalid by the Auditor General in the Free State.
By extension. In other words, if it is irregular in Gauteng, it can't be regular with you.
All right. But I understand that, well, when did you become aware of that finding? At the time it was made? You must have, surely.
The audit of I think it was 2015.
Well, do you know that payments were made pursuant to the Free State agreement? Payments were made after the Attorney General, not the Attorney General, the Auditor General had declared the contract invalid, whether by extension or not.
Yeah, but the work had already been done by that time.
But, all right, well, let's just, let me just take it step by step and take a deep breath. In the Free State, the Auditor General declares the contract invalid, correct?
Irregular. Well, I don't know whether it means the same.
And you become aware of that?
Yes, we become aware through the audit that this particular contract is irregular in Gauteng, and therefore it cannot be regular.
Is it correct that after you became aware of this fact, payments were still made to the service provider in relation to the Free State contract?
Because the work was done.
Well,
All right.
is that,
I didn't hear that answer.
Okay, I'm saying the work was already done.
Yeah,
well,
okay.
let me
Now,
ask for,
What we could not continue with is the second phase
Yes,
of the contract.
okay.
The only thing that we could, because ordinarily, Chair, if something is declared irregular, right, there is a certain framework that you'll have to follow, right? What happened? Who was responsible? For example, and whether there was value for money that was received. Now, the only thing, and who's responsible obviously will lead to certain consequences for that particular individual or individuals that caused the irregular expenditure, because you have to investigate and so on and so on. Now, in this instance, work was done. Completed. Now, the question is value for money, which is a point of contention even right now. You'll recall also that was there was a case or a judgment which was sponsored by a political party. Now, I'm aware that it was not, or perhaps we're informed that it was what was decided there was not on merits. In other words, whether the contract is irregular or not. But part of what was in that particular judgment, which perhaps maybe for people like ourselves created a confusion, was a finding that says there was no overpayment, because that was also part of the issue. Also, whether we paid, the department paid too much for that or not. Now, that in that judgment, it says there was no overpayment, perhaps on probabilities. Now, if you have that, that's assertion that says there's no overpayment. It sort of in a way suggests that value for money was received. So what remains is irregular expenditure has occurred. Who's responsible? Then we have to do that particular investigation to say, okay, how did it occur? What systems are we going to put in place to ensure that there's no recurrence of that in the future? Now, so those payments were made on those in terms of that understanding. That says at the time value for money was received. However, subsequently, then came in the investigations by the public protector, which then, as management, we're of the view that, instead of continuing, there's an investigation that is going on. So let's wait for the outcome of that particular investigation, because it is done independently, and see to what extent can we apply the consequence management thereafter. I think that has happened now with the advent of the release by the public protector of the report, which is another leg, because we thought we shouldn't do it internally, because the alternative was to do that internally. But now you run the risk that if you clear individuals, for argument's sake, and the public protector comes in now at a later stage and find against, we'll then have to revert back. So the consequence management of that action is now happening because of what the public protector is running, and I think it also applies to me as an accounting officer, and this is what is happening now. The other part is okay. That's thank you.
Mr. Pretorius.
The position is as follows then. The Auditor General in the Free State declares the contract, the asbestos contract, irregular or invalid. You continue to make payments nevertheless, and you say the reason you did that was because the work had been done.
And there was a judgment which said there was no overpayment.
Yes.
I think he gave those reasons.
Yes.
But yes, I understand that, but that we can investigate as to whether that is...
But also, Chairperson, I think, if something has been...
don't put it on.
Sorry. Yeah, if something has been declared irregular, depending on where it is, let's make a simple example. I ask you to build a house, you complete the house, and after you have completed the house, I have to pay you. The auditor comes and say it is irregular. Right? Now, you can't say I'm not paying you and keep the benefit. And those are some of the considerations that you have to take into when you decide to. Obviously, you cannot continue with the contract. Okay. The contract ends there, and we could not also continue with a second phase.
All right. I don't want to debate the law with you, but the principles upon which an enrichment claim, which is the legal term, would be calculated would be entirely different from the contract. If the contract is declared irregular, my understanding of the law is that the contract cannot therefore be enforced from either side. But if a party has benefited unduly from the implementation of a contract, there may be circumstances where that party may still recover payment, but the principles are entirely different. And would have resulted in a different financial outcome. But I don't want to debate the law with you in that regard.
Yeah.
We know the facts. Let's just go to another letter, please. Before we go on, when the public protector issued her report, payments were stopped, correct? Correct?
Is that a yes?
Yes.
All right,
Yes.
let's go to
And
another
the reason being,
Yes.
in the main, right? One of the issues that was mentioned in the public was value for money, right? And in the main. Now, you don't continue when there's already that particular finding of value for money.
You don't continue when?
I'm saying, the reason being, one of the issues that was raised by the public protector was value for money. So
Yes.
it needed also to be exhausted indeed to find out indeed is this correct or not correct. And it's also going to come out perhaps because there has been a proclamation on this matter by the SIU, which I think in their mandate, that's also what they have to determine.
You say value for money was one of the issues raised.
One of the issues.
Yes, well, I must just say for the record that if the contract was invalid as a result of anything found by the Auditor General in the Free State, the same or similar principles of value for money, unjust enrichment principles would have applied. But again, perhaps we shouldn't debate that law. It's quite complex.
But, you know, when an irregular expenditure has been determined, you know, there's a process, what they refer to as the write-off.
There's a process?
Of write-off.
Yeah, of write-off. Write-off some debts.
Of the irregular expenditure, right? And you also go through that particular process. Now, the AG will never allow you to write that off if he's not satisfied with what we have done. Now, he has, you know, it has been written off, basically. So, I don't know as to, because the determination of the value for money as well is also the part of whether you will be allowed to write off that particular irregular expenditure or not.
Perhaps you could answer this question and then we can move on. In terms of all the regulatory prescripts that would bind an accounting officer, if a contract is declared irregular or invalid by an Auditor General, as happened in this case, what are the duties that rest upon an accounting officer?
Okay. The first thing is you investigate. You investigate, okay, as I've indicated, what happened, right? Who is responsible? Did we receive value for money? Because sometimes terminating the contract can actually be very costly in certain instances. I'm not saying in all instances, but there might be, particularly in construction. You can actually end up with a bigger bill than you anticipated, simply because you chose to write off the contract. Also taking into consideration that, you know, your own internal issues cannot be, okay, I suppose I'm talking to a judge and a lawyer here, but your own internal issues cannot be at the prejudice of external parties who are not part of your processes. They have delivered what you asked for, and then you come up at the later stage and say, no, this contract is irregular, and therefore I'm not going to pay you, but you keep the benefit. I understand. Look, I don't want to, as you say, Mr. Pretorius, I'm not a lawyer, so, but that's basically sometimes where you have to, apply your mind in terms of whether you have to not to pay, and if you're not going to pay, why are you not paying if you have received the value, and what informs that?
Let's avoid legal terminology then, because it seems to me that the principles that you've been dealing with now are reflected, at least to an extent, in the law. But let's leave the law to one side. As I understand your proposition now is that once you had learnt that the contract was irregular, you would have investigated whether there was value for money received by the department for which it should have paid or should pay. Do I understand the proposition correctly?
Yes.
Did you, you say yes?
Yes, I'm saying you investigate and
Yes.
what happened.
Yes, and particularly under the heading value for money. Because as I understand your proposition, if you've received value for money, you should pay for it.
Yes.
Did you investigate whether the department had received value for money?
Yes, we obviously we use the internal expertise to say, okay, fine. In respect of this particular project, did we receive, was the work done as it was supposed to have been done?
There are two different questions, Mr. McKessie. The first question, and what you have been speaking about, is value for money, not whether the contract, the performance under the contract was carried out. The question is value for money, because remember the contract is now set aside, it's irregular, so we're now looking at value for money. Did you investigate whether the department had received value for money?
Yes, we did investigate whether the
Who did that investigation?
The project management unit did that investigation.
Did you?
In terms of the terms of what was supposed to happen, and so that we did.
No. Once again, I'm asking about the prospect, or not the prospect, the concept of value for money which you have just raised. Did you ask for an investigation to be conducted when it was drawn to your attention that the contract was irregular, to be conducted into whether the Free State Department had received value for money, as opposed to whether the terms of the contract had been carried out?
Mr. Pretorius, I think I've answered that question. I said we did. You might not agree in terms of what has transpired, perhaps right now, Chairperson, to say, I don't think you did.
Was this investigation carried? I'm sorry, I interrupted.
Let him finish.
In the normal course of events, you know, when an irregular expenditure happens, that's exactly what you did. And the AG will never allow you, because they will also do independently, of course through a sample basis, because it's not about they sample their investigation as well, to say fine was, you know, on a basis of a sports day. If for any other reason they are not happy around what we did, they will not allow that to be written off. They will not allow that irregular expenditure to be written off. So maybe not to your satisfaction, I don't know, but we did.
Well, the question that arises out of what you have said, Mr. McKessie, let's take it step by step. When you learnt as accounting officer of the fact that the contract had been declared irregular, right? You, as accounting officer, must have been concerned having received that information, surely.
Okay.
Yes, right?
Yes.
What was important to the department, and particularly yourself, in regard to whether further payments should be made, was whether the department had received value for money.
Yes.
Did you ask anyone to investigate whether the department had now received value for money?
I've just said we did, all right?
Who did you
Number
ask?
two, no, the production, the project management unit, and the head of the project management unit is Mr. Maket. But coupled with that, we also had this court judgment, which in a way suggested that there was no overpayment, because that was also the concern, to say we might have overpaid in this instance.
All right.
And it was also a matter of contestation in court as to whether we did or we did not. But, you know, the court did not pronounce itself on whether a contract was irregular, and that was not the issue. But they did pronounce on that particular issue.
That court judgment, you could give us the reference, I presume.
Yes, that's how I understood it.
Right.
At
Well,
that.
the investigators may ask.
And also internally, got assurance from, you know, from the legal division that indeed it basically says we did not overpay.
Well, the evidence before the commission to date indicates that there was a gross overpayment. But let's put that aside for the moment. I would like to interrogate that judgment, and perhaps we could get a reference from your attorneys in due course. But the question I have is, you asked the project management unit to investigate the issue of value for money. Did they provide you with a written report? Yes.
Yeah, normally what will happen is that because the preparation we would have a register of all the irregular expenditures that have been identified. Okay. And then there will be a preparation on those irregular expenditures that we that we have been able to resolve, and this one included. And then there will be that report that says, which we can also make it available to the commission around how that was written off.
Yes. Well, I'm not sure whether we're necessarily talking about the same reports, but I understood your evidence to be that as an accounting officer, you would have received information that the contract in the asbestos project was irregular. You would have asked your project management unit to investigate whether you had received value for money. And my question is, did you receive a report pursuant to that request?
Yes.
And that report, was it in writing?
It was in writing with all other identified irregular expenditures, and not only that.
You see, the question I have, did you, in this particular case, ask the project management unit to report to you in relation to whether in this particular contract there was value for money? Did you make that request? Or are you relying on a general procedure?
In every irregular expenditure, value for money comes into play, in all of them. Not only the asbestos one, but in all irregular expenditures that have been identified, value for money is always.
Yes. Is that a practice that exists?
Practice. It's a practice.
Well, I'm not asking about a practice. I'm asking you about a particular request arising in the particular circumstances of this case. You receive a report that a contract is irregular. You know that certain payments may still have to be made. You then decide that the value for money is an important consideration as to whether these monies should be paid or not. And I'm asking you whether you requested your project management unit to give you a report. You say yes. Now, I'm not talking about the practice that exists in relation to all irregular expenditure. I'm talking about a particular report in a particular circumstance. Did you ask for such a report?
Yeah, the report, what happens is that in a particular year, there will be an issue that says the following contracts or the following expenditure are irregular. Some are easy to resolve, some not. Now, those that are easy to, or those that have been apparently resolved, then there will be a one report on all of those particular irregular expenditures.
And that happens as a
and that's
matter
how
of
they've been
practice.
treated, whether it's the right thing to do or not, but this is how it has been done. And that information will then be made available to the Auditor General in terms of whether he agrees or not.
No, I understand that evidence.
So I don't know what more I should say
No.
in this particular
Well,
issue.
perhaps just deal with the question,
Okay,
Mr. McKessie.
okay, Mr. Pretoria. So maybe part of the problem is that at some stage or another on both sides, I think, the one starts talking before the other one finishes. So let's try and avoid that.
Right, point taken, Chair. But it's necessary to be laborious over this issue, I'm afraid.
Yeah.
You've referred, Mr. McKessie, to a practice that exists in relation to a report or reports on all irregular expenditure. That would happen regardless of whether you instructed a particular report to be provided for you. Do I understand it correctly?
I don't know why you want to single out this particular one to say it should happen differently.
Okay, let's put the question this way. Is it true that when there is irregular expenditure, there will be a report dealing with irregular expenditure without necessarily you instructing that such a report should be prepared? In general,
That happens as a,
as a practice.
It must happen. It must.
Yes.
That's what is required.
Okay, yeah.
Okay.
So your answer is yes.
Yes. Now the question is, who is in the?
Hang on.
Okay.
Yeah, don't go to the next question. So the position is that if there has been irregular expenditure, there will be a report. You don't have to instruct particularly that a report be prepared because it's a practice or it's required. All concerned know that it's required. Is that right? Yes, okay. Now, Mr. Pretoria, I think that clarifies at least part of your question. You have a follow-up question, I think.
Yes.
Yeah.
So I understood you to say now in this series of questions, Mr. McKessie, you said in this particular case, you asked your project management unit head to give you a report on the issue of value for money in the asbestos contract. Is that correct or not correct?
Because they have to do it because it is.
Hang on, Mr. Moketsi. Hang on. At this stage, you just need to confirm whether you did instruct a particular unit to prepare a report for you on whether there was value for money in this contract. Is that factually true?
Yes.
Did you do that?
Normally, what happens? We have a committee which we refer to as a irregular expenditure committee. Mm-hmm. Okay.
Irregular expenditure committee.
Irregular expenditure committee. I'm not.
That's for the department.
Yeah, I'm not part of that.
Yes.
Because the reports that comes from there will then ordinarily come to me. Right?
Yeah.
Now, all those identified irregular expenditure will then go to that committee.
Yes.
Okay. And They will be deliberated there. It's got a chairperson and so on, but the key players in that irregular expenditure will be the CFO and
Yeah,
and some of the senior managers.
yes,
Now, out of that will then come a report
to you.
on every irregular expenditure that has happened, right? To say, okay, this particular one, this is how we are going to deal with it. This is how it must be dealt with.
Yes.
With those recommendations.
Yes.
Like,
And included in that
now
report.
there will be minutes on that and so on. Yeah.
Okay. Included in that report would be the topic of whether there was value for money in each case where there was irregular expenditure, or would it not be like that?
Yes, there will, in certain instances, it's easy to determine whether there was value for money
Yes,
or not. But in
yes.
certain instances,
It's not
you still need a technical unit
Yes.
like the PMU to so go out and find out whether there was
Value for money.
value for money and so on.
But would it be correct to say that report that comes from that committee, that the report that comes to you on irregular expenditure, would it be correct that it has to address that issue of value for money? Whether it says, yes, there was value for money, or no, there was no value for money.
It has got to address.
It has to address that
It has
issue.
got to address that issue.
That issue.
And, you know, in this particular instances, I'm not saying, you know, value for money, etc. I don't know at this particular point. I cannot, with conviction, say that.
Yes.
Right? Because, you know, we relied originally on that court case, but there have been subsequent investigation thereafter, and now
Public
the
protest.
SIU. I think that will settle it at some to see.
Yes, okay, no, let's stop there. So as I understand you, there is a committee, an irregular expenditure committee that looks at all irregular expenditure within the department.
Yes.
And that committee interacts with all role players affected by irregular expenditure, items of irregular expenditures in the department.
Yes.
And they prepare a report that comes to you. And one of the issues they must address in that report in regard to each contract is whether there was value for money. Even without you saying anything, they know that that report must say whether there was value for money or there was no value for money.
Yes.
Yeah, okay.
And is it on the strength of that report, Mr. Mkesi, that you or the department decided that payments should continue to be made to the service provider in the asbestos project?
On the strength of that, plus, as I've indicated, on the
All right. So
on the order.
So is it fair to say then now, with your recent answers, that in this particular case, having received a report from the Auditor General in the Free State that the asbestos contract was irregular, you didn't, of your own initiative, cause an investigation into value for money to be made? You didn't do that? You see, what the chair has made very clear, Mr. Mkesi, is that this is a practice that occurs regardless of whether you intervene in any particular case or not. All irregular expenditure is examined by the committee in the department, and it will then report to you without your initiative having been taken in any particular case, correct?
Yeah, and the AG might agree or disagree with it.
Yes, no, but my question is, earlier I understood you to say that in this particular case, you approached, at your own initiative, you approached the project management union unit, and you ask them to give you a report on this particular case as to whether there was value for money. Is that correct or incorrect?
No, the issue of once a irregular expenditure has been identified, it's practice, because if you don't deal with it,
Yes, hang on, Mr. Matsedi. We know now what the practice is, you have told us. Okay. Mr. Pretoria's question is whether his understanding of what you said earlier is correct. And his understanding is that you said earlier on that you had asked a particular unit, I think project management unit, to prepare a report for you in regard to this contract on whether there was value for money. So your answer should be, yes, you understood me correctly, or no, you did not understand me correctly.
Chair, okay, let me put it this way. Every irregular expenditure, I ask the responsible, because we said in...
Okay, I'm sorry, just repeat that.
I'm saying in every irregular expenditure that occurs in the department, I asked the relevant user department, which has got the expertise on, to investigate that, because it's also part of, we have an audit action plan, right, that will identify specific areas of concern and so on, to say, okay, this is what the age is, this were the findings in that particular year, and in those findings, one of them would have been irregular expenditure, and this is how it is being made, right? Now, all those issues that have been raised on, we then put that in terms of the action plan and say, right, you do it. Who, the monkey is on whose back? It is on this particular one, it's you. On that particular one, it's corporate services, for example, if it's something that involves issues of employment, which were not done properly.
Okay,
so it's and this is what I'm trying to say when the AG has finished or has done with this report, we take that particular report, we put it up in a form of an action list that says who is responsible for what, and that will also have included this matter.
Okay, Mr. Mufetz, it may be that it's been a long day, and you are the one who have been asked questions the whole day, but it's a very narrow question. Forget about what normally happens. Mr. Pretoria's question is, in regard to this case, is it correct that you said earlier on that you instructed or asked the project management unit to prepare a report and tell you whether there was value for money? Is his understanding of what you said correct? Did you say that or not earlier on? Or are you not sure?
Chair, yes, as you say, it's a long day. How we because I'm trying to explain by saying every year, right?
Yes, but I don't want you to explain now. I just want you to try and remember whether you did tell me that in regard to this case, you asked the project management unit to prepare a report.
And so is on all other cases. I don't want to, and so is on all other cases where the expenditure has occurred. That will happen. To say, okay, this is yours. This is what I'm trying to say.
But you see, the question is not about other cases.
Okay.
Yeah,
yes.
So in this case, you did.
Yes.
Okay, all right. Thank you. Mr. Pretorius.
All right. Just one more question then on this issue, Mr. McKessie. Apart from the system you've described that was in place, whereby all irregular expenditure is examined in relation to value for money and other topics, and a report is presented to you. Apart from that, was there any other specific request by you to the project management unit to report in this particular case?
I'm not asking you the same question, please.
Okay, the question is whether, with regard to the project management unit,
Yes.
was there any other request you made to them in regard to this case, other than the request that they must prepare a report which would deal with whether there was value for money? Is there another request that
Another
you made?
report.
Whatever request in relation to this contract, is there another request you made to them in relation to this contract that you can remember?
There is the chairperson, the request happened in the ordinary course of business, and it was once, it was report with all these others submitted to the AG to say, look at whether you are happy with what we have done, and so on, and then particularly for the write-off, and intrinsically that is the value for money. Now, if in certain instances the AG has refused to write off in certain and has requested us to do further work, in other instances of irregular expenditure, he has instructed us to do other work, to say, I'm not happy with this, and do some few tests and explain why he's not, why they're not happy. And then we had to do other work. In certain instances, we also had to, particularly when it comes to irregular expenditure, that because we had instances where we had to deal with irregular expenditure of 2010, 2011, and we had to outsource that part. So I don't know what more I can say.
Yes, Mr. Pretorius, it may be that you need to be more specific to say, did he request APC? Then maybe that might help.
Let me just do it once, or attempt to clarify once more, Chair. You've described in detail, Mr. McKessie, to the Chair, a system that was in place whereby all irregular expenditure is investigated from various points of view, including value for money, by a committee, and you're not a member of that committee. That routinely happens whether you instruct them in a particular case or not. Am I correct? There's a standing practice and set of instructions whereby irregular...
I think don't go back to it, Mr. Pretorius. It was clarified.
Okay?
Yeah.
Is that correct? Yeah. That's correct. Well, now the question I have is, apart from that process, which happens in any event, whether you initiate it or not, did you, in this particular case, when you received the report from the Auditor General, go to your project management unit and say, I want you to investigate this particular case as to whether there was value for money in this particular case? Please give me a report.
No, I don't want to say in this particular case and separate this particular issue to the others that we are doing.
Yes,
which are of similar importance.
Yes, okay, Mr. Mokhetsi, I think we have been along that road. The answer that Mr. Mokhetsi gave earlier on was that he did give such an instruction in this particular case, but he did say that he does it so in other cases as well. But in this particular case, he said he did give. Yeah.
Let's let the record, it'll be an exhaustive read, but let the record be read and we can decide what it says.
If I misunderstood him, I'm sure we'll pick it up, yeah.
All right, perhaps you can go then to 8 FS 8 at page 176.
I mentioned for what it's worth that we are 5 minutes away from finishing an hour. We can stick to that, or we can go to 1:30 and stop at 1:30 if we
Chair,
all agree.
I had a cordial discussion with Mr. Mpofu in the break.
Yeah.
And our understanding of the arrangement was 5 o'clock.
It was 5 o'clock.
5 o'clock. So I think.
Well, it's now 5:15.
No, I understand that. So
Oh,
we've
you think
conceded
we've
that
gone
point
beyond?
already. But I'm not sure we're happy to concede yet another extension.
Okay, no, I understand why I thought that what I said was the hour would be calculated from 20 past when we came
no, it
back.
was-
But it's not an issue.
No, I've received advice from behind, Chair, that your interpretation was correct and that we were clutching at straws. But we're happy to settle for 20 past, Chair.
Yeah, okay, all right then. Okay,
If
you
that's
may
okay, I mean, if you insist, Chair, obviously,
No,
to be serious.
No, I just wanted to make sure, because 20 past might be seen as an awkward time to stop. I thought in case you say, you all agree, let's finish at 1:30, I'm quite happy that we do that.
20 past is not awkward at all.
I won't insist on going beyond that because you are the only one standing, Mr.
Yes, well,
Pretorius.
only one left standing.
Okay, so we'll stop at 20 past.
Thank you, Chair. But to be serious for a moment, if you want to continue.
No, it's fine, it's fine.
Mr. McKessie, if you would go to Free State 8, FS 8 at 176, please. That is a letter that refers back to your letter of 15 July, which we spoke about earlier. Remember that spoke about an instruction to perform work.
Page 176 of
FS8.
bundle FS8.
You have that?
It's a letter from Mr. Dirks to you. You have got it, yeah.
It's dated the 4th of August 2014, and it appears to refer back to your letter of 15 July, which we've already discussed. Now, here she says, request to appoint a professional resource team. The second paragraph reads, I hereby confirm my decision taken on 21 July 2014 that the Gauteng Department of Human Settlements granted approval in terms of Treasury Regulation 16A 6.6 for the Free State Department of Human Settlements to participate in the contract arranged by means of a competitive bidding process from the database of the Gauteng Department of Human Settlements for professional resource teams where Blackhead Consulting Pty Limited was appointed from. That appears on the face of it to be referring to a panel arrangement. Do you agree with me?
On the face of it, you
Yes.
say it appears to be from a panel arrangement.
Yes.
Okay.
You agree? Yes. Yes?
Yes.
On the face of it,
On the
appears
face of
so.
it, yes.
On
yeah.
the face of it. And once again, at this stage, references to Blackhead Consulting Pty Limited, not to any joint venture or other entity. You see that in paragraph 3.
Paragraph 3. Yeah.
You see that? She's giving her
The
approval.
paragraph that starts the approval. Is that the paragraph that starts with the approval?
The approval is subject to the conditions that Blackhead Consulting Pty Limited.
So that's the paragraph that you're referring to?
Yes.
Okay.
She's referring to Blackhead, not to the joint venture.
Yes.
Correct. All right. Let's go on then to a letter that was written to Mr. Sodi by yourself on the 11th of August 2014. Perhaps we should deal with this letter and then bring proceedings to a halt, Chair.
Yeah.
What page is that?
It's at page FS8, 179. This is a letter dated 11 August 2014. It's addressed to the CEO, Blackhead Consulting Pty Limited, and it concerns the appointment of Blackhead Consulting Pty Limited for the asbestos eradication program in the Free State province. And paragraph 1 reads, and this is under your hand, Mr. Makesi, the above has reference to the concurrent approval by the Gauteng Province Department of Human Settlements dated 4 August 2014, the letter we've just referred to, regarding your participation in an agreement currently secured by them, and it will be appreciable, you say, if you could confirm in writing the following. 1, you formally agree to participate and extend your services to the Department of Human Settlements in line with terms and conditions of their IPW instruction to perform. Now, just to put one question for the present, Mr. Makesi, it seems that on the one hand, Ms. Diedrichs was talking about a panel arrangement, which we know cannot be extended or participated in. On the other hand, you're talking about an instruction to perform work with particular terms and conditions of contract. Is that observation a correct one?
No, my understanding is that there was a contract. There was an existing contract in Gauteng for Blackhead to do this work.
Don't lower your voice too much. Don't lower your voice too much.
Okay. Chairperson, my understanding was that there was a contract, an existing contract with Blackhead in Gauteng, which we participated on. You know, the like-for-like issues that I mentioned earlier on. Now, for you to start doing work, it's one thing to say you have a contract, but in order for you to be able to start doing, you have to wait for, there must be an IPW, an instruction to perform work. And that's what we wait for. You can have an appointment and so on in the contract, but then you have to also wait for the IPW.
Yes. Well, that seems to be in your understanding, Mr. Makesi, but it doesn't seem to have been the understanding of Ms. Diedrichs. Let's leave that aside for the moment. The point about the instruction to perform work, that wouldn't have been concluded after a competitive bidding process. You agree with that? But you looked at the documentation.
That wouldn't have
been concluded as a result of a competitive bidding process. Those terms and conditions were unilaterally imposed on the panel by the Gauteng department. Did you know that? Or had you looked at the documentation, you would have discovered
which also suggests that, you know, my earlier point on to say, if the documents have been requested, you could have picked up.
If the documentation had been examined, as you say, you would have discovered that the instruction to perform work was not the result of a competitive bidding process, and therefore 16A couldn't have been applied. Perhaps we could take it that far for the present. Sure.
Maybe let me just ask this question. Was your understanding at the time that Blackhead Consulting and Diamond Hill made a proposal to the Free State Department.
Can you repeat that, Chairperson?
Okay.
I think I missed something.
Yes, was your understanding at the time that Blackhead Consulting and Diamond Hill made a proposal to your department, was your understanding that Blackhead was still continuing with the work or with some work in the Gauteng Department of Human Settlements? Or was your understanding that they had done their work and finished it?
No, my understanding was that they have an existing contract. There's work that they are doing in
Gauteng,
Gauteng.
which would explain why Ms. Didericks made the point that Blackhead's commitment to be involved in the Free State should not
affect.
negatively affect them.
Yes.
The work in
Yes.
Gauteng.
And that's why you are required also to
get approval.
To get approval and get
Yes.
that undertaking.
Yes, but if at the time they made the proposal, there was the proposal to the Free State Department, there was no existing contract for work, but there was simply an appointment to the panel, then that would not justify extending any contract because there would be no contract to do work. There would simply be an appointment to the panel. Is that right?
The panel is not a contract.
Yes, that's what I'm saying, that in order for there to have been an extension or participation in a contract by the Free State Department, then the contract for work for Blackhead in Gauteng had to be in existence in the sense that they were still continuing.
Yes, it had to be in existence at the time.
It should not have expired. They should not have finished the work.
Yes, in other words, the contract should have been valid.
Yes, should have been continuing.
Yeah. Forget about whether it was irregular or not, but there must have been a contract.
Yes, yeah. Okay, no, that's fine. Okay, we are going to stop here. I must thank everybody for your cooperation. I think we made a lot of progress. I think everybody was cooperating. We made a lot of progress. So I think next time we'll be able to finish. But it's been a long day, particularly for Mr. Pretorius and Mr. Musegi. Mr. Pretorius because he was standing, Mr. Musegi because he was answering questions. But thank you to you, Mr. Musegi. Thank you to Mr. Mpofu and the legal team.
Thank you.
And to Mr. Pretorius and his team that we have been able to go up to this time and cover as much as we have. So another date will be determined. As indicated, it may be that it will be an evening session, starting at 4 o'clock or 5 o'clock. But I understand everybody wants to cooperate to make sure we can finish. Thank you very much. Just for the sake of the public, on Monday, the Commission will hear evidence from Ms. Thomas, the former PA to Ms. Nomvula Mokonyane, about Busasa issues. We adjourn.
Thank you.
Yeah, you just leave it. You can leave it.
Thank you, Mr. McKinsey. Long day.
Oh, yes.